Hello everyone, and welcome to today's webinar. We have a great session lined up for you today. Before we get started, there are just a few general housekeeping points to cover. First and foremost, please use the online question tool to post any questions that you have, and we will share them with our speakers. There will be a Q&A at the end, and our speakers endeavour to answer any questions that you have. Second, if you experience any technical difficulties today, please use the same question tool, and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of the recording with you via email in the coming days. So, without further ado, I'd like to hand over to our speakers to get us started.
Hello, everyone. Good morning or good afternoon, wherever you're calling in from. Firstly, we want to thank Lexology Masterclass for coming up with the idea and for marketing this event. By way of introduction, my name is Simon Weintraub. I'm a partner at Arnon, one of the largest and oldest law firms in Israel. I am here together with my colleagues Avi Anouchi and Idan Adar, both of whom have extensive experience representing both lenders and borrowers in the venture debt space. This masterclass assumes a basic understanding of venture debt transactions. It's focused on terms that are specific to conducting venture lending transactions in Israel. Generally speaking, venture debt has become much more prevalent in Israel over the last 5 years or so, maybe even a little bit longer. It's particularly pushed by the VC industry, who understand that venture debt can extend runways of their portfolio companies without significant dilution to the shareholders. With that said, the recent fallout of SVB and the banking crisis in the US has changed the industry, and it's still probably early days to see how this will pan out. So just slide a little bit of information about our firm. As I mentioned, one of the largest law firms and over 420 lawyers. We are a full-service law firm. This is the agenda. I will be running the seminar together with my colleagues, as I mentioned, and we'll be splitting up the agenda. Okay, so maybe just a little bit about some of the history of venture lending in Israel. Venture lending first reached Israel, I would say, around the year 2000 when Israel set up its first private venture debt fund. The fund was called Plenus. Plenus has evolved over the years, and probably many know it today as what grew into Viola Capital. SVB, of course, had a long history. It has a long history in the Israeli tech sector, working with Israeli startups since probably the mid-1990s. It opened an office in Tel Aviv in around 2008. And in addition to providing standard banking services, SVB provided Israeli startups with credit lines on attractive terms, and even sometimes participated in equity investments. The Israeli government committee established to monitor the situation following SVB's collapse estimated that SVB had at least a third, did business with at least a third of Israeli tech companies, either as a borrower, Israeli companies either being a borrower or depositor. The SVB book of loans was acquired by First Citizens Bank, which is currently operating as SVB with respect to its existing facilities without a physical presence in Israel. And most of the SVB team had left and moved over to HSBC. With that said, I would say there are probably a number of what I call serial venture lenders in Israel who, over the years, provided many venture loans to Israeli companies even without an Israeli presence. In Israel, those include organizations like Comerica Bank, Valley National Bank, Triple Point, and Hercules. They've been active over the years, but definitely not the volume that we saw coming out of SVB. We also saw some other foreign lenders with presence in Israel. Krios Capital has been present in Israel for a long time, and they recently were acquired by BlackRock. Of course, we have HSBC today. And on the Israeli side, we still have Viola Capital, and the Israeli banks have also been involved in the space. Bank Leumi, Bank Hapoalim, Mizrahi Tfachot, and Discount Bank. Lastly, I might also mention that there are probably a number of other outfits that don't necessarily do traditional venture lending, but have kind of other, similar models, other revenue-based and asset-based lending that we, secured and unsecured that we sometimes see here. And I think that today we're definitely seeing some new players enter the market here, particularly some of the large, global financial players, and we're also seeing a number of private equity funds and even hedge funds looking to do deals in Israel. Okay. So to get into kind of the nitty-gritty of what these deals look like in Israel, I think the best way to kind of look at it is I'll try to run quickly through this to explain what you see, what goes into a standard term sheet, and what we see as terms of transaction documents. So again, in terms of term sheet, I'm not talking about all of the things that you would typically see in a venture debt term sheet. I'm talking about the things that are a little bit more Israel specific. Gross up is always a big one of these, and a little later on in the seminar, we'll talk a little bit about withholding tax, which is an issue for Israeli borrowers when they repay interest to lenders, even to foreign lenders. So if you are a foreign lender and you don't want to have tax withheld at source, and you want to be made whole, then gross up is something that needs to be discussed, and ideally discussed at the term sheet stage. I probably can't stress enough the importance of having a really good comprehensive term sheet from the beginning to kind of avoid problems and arguments when you get to the definitive agreements. Another important issue is obviously group structure. Typical Israeli startup structure usually either has an Israeli parent with a US subsidiary, although often has a US parent with an Israeli subsidiary. And some of the larger companies tend to have subsidiaries around the world. So it's important to kind of figure out how the group structure works into the transaction, and also, from a collateral perspective, particularly for the larger companies that may have subsidiaries around the world, which are the material subsidiaries, which are the subsidiaries that you want to see as part of the collateral package. Obviously, the more subsidiaries that you involve into the transaction, the higher the costs and the more lawyers that tend to get involved. And of course, the issue of co-borrowing versus guarantor. I think from a lender perspective, it's probably the best structure is to do a co-borrowing structure, and to have all the main entities sign on as co-borrowers, even if they don't both technically borrow the money, but from a legal perspective to be co-borrowers. But of course, we see many transactions where you have maybe the U.S. company will be the borrower in the transaction. The Israeli company will, either parent or subsidiary, will serve as the guarantor. It certainly works from a legal perspective, and sometimes it's preferable for companies from a tax perspective. And of course, pledges. It's important to kind of lay out exactly what you want to get liens on, which assets, and also in which jurisdictions you're going to take security. Obviously, as I said earlier, the greater the amount of jurisdictions that you use, in a particular transaction will obviously, increase costs and complexity as well. And also, with respect to the collateral package, it's important to specify all the various assets that you want to take security over. I think it's important to note that we've certainly seen as a trend, at least venture deal in debt transactions coming out of the U.S. There's been a trend for a while of getting a lien over all assets, excluding intellectual property. That is something that I would definitely say is not market standard in Israel. Obviously, most of the companies we're looking at, in this industry, in venture debt transactions, typically their key asset is intellectual property. Some of them don't have much more, very little in terms of fixed assets. So that's something that's important to kind of iron out from the beginning as well. And of course, the issue of governing law. I would say that for foreign lenders doing venture debt transactions in Israel, it's pretty common to use foreign governing law. Depending, where the lender is based, it's often California law or New York law. That works. It's enforceable in Israel. That works again for the main loan agreement. doesn't necessarily work for all the documents. Israeli security agreements should be governed by Israeli law. And if it's an Israeli company, the warrant, which is an Israeli security, should also be governed by Israeli law. So those are the things that we typically see in the term sheet. Getting to transaction documents and what documents appear in a venture loan in Israel. So the main agreement is obviously the loan agreement. I would say in most of the cases, at least with foreign lenders, we tend to see a loan and security agreement. So that agreement would lay out all the terms of the loan and would typically also serve as the main pledge agreement, at least with respect to U.S. Securitization aspects. And as I mentioned, foreign law, would typically govern on that agreement. Share pledge agreement is another common agreement, just depending on the structure. So if for example, if the parent or the borrower is a U.S. company, Delaware company, and has an Israeli subsidiary, so often you would want to take security over the shares of the Israeli company held by the U.S. parent. That can be done, by the way. It could be molded into the loan agreement and done as part of that, or you can create a separate share pledge agreement, which can be governed by Israeli law or not governed by Israeli law, but in any event would still require registration in Israel. The other key documents are Israeli security agreements. So wherever the Israeli companies fit into the structure, presumably you would want to get security over the assets held by the Israeli company. So this is done. We'll get into a little bit more in detail a little later on in the seminar. But we typically have two IP security agreements. One is called a fixed charge agreement, and another one is called a floating charge agreement, and governed by Israeli law. As I mentioned earlier, many of the transactions have a guarantee, as an example, if you provided a loan to a U.S. company, which is could be the parent or the sub, very often you might see the Israeli company serving as a guarantor under a guarantee agreement. Guarantee agreements, also governing law tends to follow the main loan agreement, and probably most of the transactions that we see, the guarantees are secured, but sometimes it could also be an unsecured guarantee as well. The warrant is obviously a very important part of all venture debt transactions. Israeli warrants look pretty similar to what you would see as to U.S. style warrants. There's a little bit of differences in some of the legalese and terminologies, but generally the mechanics are quite similar. As I mentioned, governing law should preferably be Israel because the warrant is an Israeli security. And by the way, it might also have provisions that tie into the company's articles of association. For those not familiar with articles of association, it's something you will be familiar with if you do venture debt transactions in Israel. The articles are the governing documents of a company. As opposed to U.S. companies, everything gets thrown into the article. So it's like a COI, shareholders agreement, right of first refusal agreement, voting agreement, kind of all wrapped into one. In terms of security over cash and bank accounts, so for bank accounts held outside of Israel, it's common to enter into DACAs, deposit account control agreements like you see in the United States. It is important to note that Israeli banks do not and will not enter into DACAs. At most, what you can get from an Israeli bank is an acknowledgement over the pledge. Most Israeli bank accounts have restrictions on the ability to pledge that account without their consent. And I would say that the last document that's part of Israeli transaction documents is the legal opinion. We definitely see a trend, at least in the U.S. markets, of fewer legal opinions. Many deals I know are being done without legal opinions. But I would still say this is the market norm in Israel, and in our experience, most foreign lenders, when they do cross-border deals into Israel, they tend to ask for legal opinions from borrower counsel, even if they're not going to ask for a legal opinion from U.S. counsels. They tend to typically still ask for and require legal opinions from Israeli counsel, Israeli borrower counsel. And those opinions they're not complicated opinions. They tend to cover capacity and also enforceability of the pledges. Okay, so with that, I'm going to pass it on over to my partner Avi Anouchi, who will continue on the topic of taking security in Israel.
Hi everybody, pleasure to be here today. So as Simon mentioned, the Israeli security agreements, you would typically find a fixed and a floating charge agreement or debenture. The difference between the two, the fixed charge can only be entered into with respect to existing assets, which have to be specifically set forth within the agreement. These assets would typically include a list of all the company's fixed assets, equipment, registered and unregistered IP, bank accounts, and other commercial agreements for which there may be receivables. The floating charge, on the other hand, crystallizes only upon realization and floats over all the assets of the company, and does not specify any specific assets, and thus allows us to capture everything that the company may have in the future. Both of these agreements, in order to perfect them, need to be filed locally in Israel. The filing is required to be made within 21 days. The local law allows for retroactive perfection to the date of creation of the security interest, provided that the filing was made within that 21-day window. So there's utmost importance to make sure that the filing happens on time. One nuance specific to Israel is that this filing process does require wet ink signatures. So that's just something to keep in mind process-wise when handling a transaction. Beyond that, another distinction between a fixed and floating charge is that the floating charge, following a recent change to the Israeli insolvency law, limits the secured lender to up to 75% of the proceeds from the realization of the assets secured by the floating charge. The remaining 25% would then be allocated amongst all unsecured creditors, and that would include the secured creditor to the extent that the 75% of available funds were not sufficient to repay the debt. So any deficit would then be folded into an unsecured status, and the secured creditor would participate with the rest of the creditors of the company. The other important thing to note is that in order for an Israeli company to give security over its assets, it has to meet a basic solvency test, and the primary check for solvency is a look back of 3 months, checking the company's solvency. And this obviously is picked up in standard reps given by the company in transaction documents, confirming that the company is solvent. Another perfection requirement in Israel, specifically with respect to IP, is that the pledge of patents is required to be also filed separately with an additional registrar, with the registrar of patents. And this too, again, requires 21-day filing. The filing, as with the company's registrar, which is the primary registrar for filing security interests, requires filing of the agreement itself. This is important to note because once you file the agreement, it becomes part of the public domain, which is another reason why security agreements in Israel are broken out from the loan agreement and not folded in as is customary practice in the United States. The other registrar is the registrar of pledges, and this would be relevant for registration of a security interest of a foreign entity over Israeli assets. Here I'll just pause to make note that the shares of a Israeli subsidiary owned by a foreign entity, the shares themselves are considered an Israeli asset and would need to be registered here locally with the Registrar of Pledges in order to perfect that security interest. And here, as opposed to the pledge by the Israeli entity, which would have retroactive effect, retroactive perfection, as long as it's filed within the 21 days, the Registrar of Pledges perfection is only upon filing. So if there's delay in filing, that would delay the perfection. So it's crucial that the process for filing happens as close as possible to the closing of the transaction. Enforcement of a security interest is typically done through the courts. As opposed to other jurisdictions, there's no self-enforcement right. So a creditor will need to go and enforce the pledge via Israeli courts. Israeli courts will recognize foreign judgment to the extent there's a foreign governed pledge, and that can be also brought to the Israeli courts for enforcement. I'd also like to raise a recent court case. The Supreme Court ruled this past September in a new decision with respect to floating and fixed charges and the characterization of these charges. And the court made a distinction specifically with respect to cash and bank accounts and receivables from customers, and distinguished that despite the party's intent that there should be a fixed charge over those assets, the court was had the authority to go and reassess and recharacterize those pledges and look at the substance to see whether or not the pledge was actually a fixed charge or in reality a floating charge. And in that landmark decision, the Supreme Court determined that there was not sufficient control over the asset, and there was not and further that there needs to be sufficient specificity in the agreements in order for the court to recognize a fixed charge. So without having sufficient specificity or control over the assets, the court would be inclined to go and recharacterize a fixed pledge as a floating charge. So this is important to take into account when the primary assets of the pledging company are bank accounts and receivables. All right, moving on from enforcement, another important nuance of the Israeli ecosystem is the existence of the Israel Innovation Authority, formerly known as the Office of the Chief Scientist. For those of you who've been in the market longer, the Israel Innovation Authority provides grants to Israeli startups, funding all sorts of R&D programs. The grants are non-dilutive, but obviously there's no free lunch. The IIA receives payment through royalties from sales of services or products by the companies with respect to the IIA funded programs. And further, there's a restriction placed on an Israeli IIA funded entity from moving or transferring its IP out of Israel. At the end of the day, the Innovation Authority is interested in guaranteeing more jobs here in Israel, and they look to make sure that the IP and the core assets and further R&D remains local in Israel. How does this impact venture lending? Well, in order to get security over an IIA IP in an IIA funded company, you would need to either notify or receive consent from the IIA. This process is typically rather quick and takes about 2 weeks, up to 2 weeks usually, depending on the timing of the next IIA committee meeting. But this approval is usually granted. It is typically conditioned on the lender signing a standard form undertaking committing to comply with the Israeli R&D law, which amongst other things requires that the company retain its IP in Israel and that any transfer of IP out of Israel be done with the consent of the IAA and payment of certain exit fees for transfer of the IP out of Israel. This would typically be between 3 to 6 times the grant received by the company from the IAA. This obviously would come into play to the extent there's realization of IAA-funded IP. The creditor would still need to go to the IAA and discuss any transfer of the IP outside of Israel. However, if the acquiring entity in the enforcement proceedings keeps the IP in Israel, then consent and the exit payment would not be required. And finally, I just say that while the IAA is quick in its decision-making process, most grants are notice only, but there are grants that do require consent, and you can contemplate having a post-closing covenant to notify and obtain IAA consent depending on the circumstances of the transaction, and then the fixed and floating security agreements would usually include some sort of springing provision that the pledge of the IAA-funded IP would only become part of the collateral package once the consent is obtained. But obviously, this needs to be reviewed within the specific framework of the transaction. With that, I'll hand it off to Idan.
Thanks, Avi. Hi, everyone. Thank you for joining us today. As Simon alluded to a little earlier in the presentation, in accordance with the Israeli tax ordinance, the ITO, any interest payment made by any Israeli loan party to a non-Israeli lender entity, that's a non-individual, is generally subject to Israeli withholding tax at a rate of 25%. Though that rate may be reduced by either an applicable tax treaty, which has, amongst other things, certain conditions, and setting forth that the lender is entitled to tax treaty benefits. For example, in the US and Israeli tax treaty, interest payments made by an Israeli loan party to a US resident bank or savings institution or insurance company and similar entities with respect to a loan granted by such US entity is generally subject to a reduced withholding tax rate of 10% when certain conditions are met. And for other US entities such as hedge funds and private equity funds and the like, the reduced rate is only 17.5%. That being said, it's worth noting that the tax treaty treatment is not automatic, and either one of the lender or the borrower, and that's usually a commercial matter that's agreed between the parties as part of the transaction, needs to apply to the Israeli tax authority, the ITA, for the reduced withholding tax rate under the US-Israel tax treaty. So that it can apply with respect to any interest payments made to the US lender entity. And that's the same goes for any tax benefits under double tax treaties signed by the State of Israel. So as part of that process, the US lender is required to obtain a written approval from the ITA stating that it's eligible for such a reduced tax rate. So essentially they receive a withholding tax certificate. And without such certificate, the Israeli loan party would generally be required to withhold 25% of tax on interest upon the payment of such interest to the US lender. It's worth noting, though, that some Israeli-based foreign lenders have actually managed to negotiate a reduced rate of withholding tax, or even a general exemption altogether from withholding tax. This can be done through several months of negotiations opposite the ITA, but it has been known to happen, and there are a few existing Israel-based foreign lenders who have this in place at present. So with respect to the gross up, Simon gave a little bit of insight on this earlier. Basically, it's a commercial discussion at the commercial level between the lender and the borrower entity. Usually, it's common for the lender to include a gross up provision in the loan agreement, which would ensure that the amount payable to them would be ratably increased, so that following any withholding, whether it's at a rate of 25, 17.5, or 10%, if we're talking about the US-Israel tax treaty, would be paid out to them as if there'd been no withholding at all. So in other words, it's a full tax gross up. That being said, in our experience, in order to be more competitive, certain US lenders or other foreign lenders sometimes agree to take the burden of withholding up to a certain percentage. Commonly, we see up to 10%, depending on certain conditions. And then in that case, the gross up would only apply for any withholding which is above a rate of, based on my example, anything above 10%. Just another thing to note that VAT is in Israel is at a rate of 17% and does apply to certain Israeli sourced loans with respect to interest payments and various other banking fees. One other new method which actually could basically be an exemption on tax payments for interest paid to US lenders is a very recent from last week, in fact, law which has a kind of nickname, been nicknamed the Angels Law, which is basically a law that encourages investments in knowledge-intensive industries. So, in other words, the Israeli high-tech industry. And among other things, this new Angels Law basically grants certain tax benefits to investors and incentives for purchasing other tech companies if the IP of the relevant company is registered in Israel and their operations are based locally. So there's also, as part of the new Angels Law, there's an exemption, a full tax exemption, I should say, with respect to interest payments on loans provided by certain foreign financial institutions, though these are subject to certain cumulative conditions, two of which are that the borrower entity, their technology revenues in the tax year preceding the provision of the loan was over 30 million shekels. And additionally, that the loan amount in the loan transaction is at least $10 million. So while these exemptions are generally speaking welcome, they would seem to exclude actually a majority of the venture lending transactions from being eligible for such an exemption. So they didn't seem to take too much into consideration regarding the venture lending community in this respect. So we'll see if that changes in the near future, hopefully. Just one last thing on the new Angels Law. Is meant to remain in effect currently until the end of December 2026. Another regulatory issue is the question of whether or not you would need a license to lend in Israel. The short and simple answer would be yes, but. So according to the Israeli Financial Services Law, the extension of credit by non-Israeli licensed banks or institutional investors is subject to a license requirement. However, the Israeli parliament has enacted certain regulations which would exempt foreign entities from this license requirement. So, for example, there's a general exemption to banks which are incorporated in OECD member countries or who are licensed by a regulatory authority in an OECD country. There's also an exemption to providers of credit who only provide credit to corporate entities, provided that such transactions are not less than 3 million shekels. And actually the most common exemption when it comes to venture lenders in Israel is an exemption for providers of credit to corporate entities whose main activities are research and development or the production of innovative products or processes, and to whom it's considered to be a greater risk to lend money to compared to other investments. Another potential exemption from the financial services law would be, and this depends on the specific fact pattern of the loan transaction, but there's a territorial application basically by the specific regulator for the financial services law, which says if the Israeli nexus in a transaction is minimal, then it would probably be considered exempt from the license requirements under the financial services law. And without further ado, I'll pass it back to Simon.
Thanks, Idan. So I guess just to conclude, a couple of main conclusion points on our end. Firstly, venture loans are quite similar in Israel compared to US-based venture loans. We definitely have issues that are Israeli law specific, and hopefully what you can see from the presentation require consult with qualified Israeli counsel. Probably worth mentioning as well that the large international law firms, many of which have small office branches in Israel, are not providing local law services. So even when we do see foreign lenders, and often they're comfortable and they want to work with their foreign counsel, it's great. We work with co-counsel all the time from around the world. You'll always need Israeli counsel in order to advise on specific Israeli law issues and of course taking security in Israel. Another conclusion that we have is that the significant decrease in SVB activity in Israel, coupled with increase of Israeli interest in seeking venture debt in a market where equity is much harder to come by, valuations are much lower, create new opportunities in Israel. This past year, we have certainly seen a lot of increased activity from new players, such as private equity funds and hedge funds, and we are starting to see some of the very large financial players, open up offices and be involved in this industry. So, those are exciting trends. I think to conclude, we'll open it up to questions. I see a few questions that we did receive, and I'll be happy to take a stab at answering them. There's still a little bit of time, so if people have additional questions, feel free through the question box in the program to put in your questions. So I guess I'll start with the questions that I see so far. One question that we received is, how long does it take to complete a venture debt transaction in Israel, and what are best practices? So I guess what I would say is that a venture loan, in our experience, typically takes about 6 to 8 weeks to complete from the signing of the term sheet. It can take longer depending on the amount of negotiation, the familiarity level of the borrower and their legal counsel. it's important to set expectations in time frame from the beginning, and also to think ahead of what issues might be outside of their control. So some of these things were brought up earlier in the presentation. Things like, is there intellectual property being pledged of the from the Innovation Authority? So do we need to get their approval? These are things that are better because of the timing aspect, better to think about ahead. And also sometimes we have existing debt providers that need to be taken out. Those sometimes can be a little bit tricky. The payoff letter and the swapping of security can sometimes be a little tricky in Israel. These are just examples of things, at least in our experience, which better to think about earlier on in the process, to have a smoother process. Let's see. Another question that I see here is, what happens if things turn sour between lenders and borrowers? So obviously, in the the many years that we've been involved in this industry, we I'd love to say that every deal was a smashing home run. It isn't always the case. With that said, I think it's important to note that it's very, very rare to actually see a pledge enforced by a creditor. I can count on less than one hand the amount of times we've actually been involved in those types of processes in venture loans. Typically, the parties will manage to reach some kind of amicable solution where they will they'll amend the loan documents, enter into as many grace periods as they can, and sometimes if nothing can be solved, they'll find ways to sell off the assets of the company together and to try to reach an arrangement outside of the court system. I think we have another question here as well. Maybe Avi, you'll take the third question that we got in.
Yeah, I see are venture loans being made to pre-revenue development stage companies following substantial angel round in anticipation of a Series A. So certainly that was something we would often see SVB doing in the past. I think that current market trends are changing a bit. The pre-revenue funding was definitely quite common. Usually these were smaller term loans in the ballpark of 1 to 3 million. Obviously the collateral package was minimal to nothing, and just the basic IP. But yeah, those are definitely transactions that we see in the Israeli market, although time will tell whether we'll continue to see those at the same level that we previously did. Another related question I see here is about current market trends. So here, again, I would say that there's been a slowdown as far as smaller companies. I think lenders have become a little bit more strict with their analysis of companies and what they want to fund. I think that the terms of these loans have also become more lender friendly. Specifically, I'm starting to see more covenants being added, in particular financial covenants, something that SVB was really nice and not usually including, which was very nice and friendly, company friendly from our perspective. This is not the case as much anymore. I'm starting to see more transactions requiring basic financial covenants throughout the life of the loan.
I see also a question here on gross up, and when there is a gross up, how difficult it is to get the deducted amounts back. So obviously qualified. I'm not a tax expert. I know it is possible, normally to try to get to collect those deductions back to get a tax credit. Often we've seen lenders in the U.S. apply for these for tax credits. With that said, I think it's not an easy process, and also depending on the size of the organization, certainly with foreign banks, it could be quite a complicated process. So it's also tends to be an operational question that may not be suitable for everyone. I see also that someone else also asked whether or not you can get the presentation, and the answer is yes, and we'll find a way to send our presentation to the distribution list. Okay, I don't see any other questions. I don't think. Avi, do you see any more?
No.
Okay. Great. So I think with that we can probably end here. Thank you for listening. As mentioned earlier, the session was recorded, so I imagine it will be possible to get a copy of the recording, and we'll also make sure to send out a copy of the presentation. So thank you very much for taking time out of your busy schedules to listen, and thank you to Lexology for helping put this together.